I'd like to give you a warm welcome to the law school, but the temperature outside has foreclosed that. So thank you all for coming in this rather unpleasant weather today. Our Dean, Larissa Litsky, would also like to extend her, metaphorically, warm welcome to you all. Unfortunately, she's not here, but thank you all for coming today. I'm very excited about today's program. We are honored to have a fantastic lineup of speakers and panelists, and I know it will be a very intellectually stimulating day. I had not thought about a general framework or theoretical approach to regulation until I had the opportunity to read How to Regulate by our colleague, Professor Tom Lambert. If you've not had the chance to read his book, I hope you do after the symposium. It really is an extraordinary work. It's theoretically sophisticated with scholarly insights. It is practical and useful to policymakers and regulators and professors, among others. And at the same time, it's incredibly accessible and enjoyable to read, even for folks like me who are not often confident reading economic analyses. I'm very happy we'll be honoring his work today with our discussions today. Along those lines, I'd like to thank our guest speakers and panelists today who have traveled in this unpleasant weather to be here. We are honored to have you here. Thank you so much. I know that BETR is also really excited to publish your contributions after today. So again, many thanks. I'd like to thank our faculty organizers, Professor Michelle Cecil, who is just fantastic at hosting and organizing events at the law school. Professor Cecil is, I don't think I'm speaking out of turn by saying we'll be retiring at the end of the year, and I fear that she won't be organizing many events, but I hope she will. Many thanks again to Professor Lambert for putting together such a terrific program for today. Many thanks are owed to our students of BETR for putting together today. Special thanks to Kenyon Briggs, its editor-in-chief, who I believe had the idea for today's focus and topic. Many thanks also to Larissa Tiller, who in addition to being the lead articles editor, also took the lead with so many of the logistics for today's program. So again, many thanks. I'd like to thank the Charles Koch Foundation for its generous support, providing a grant for today, which among many other things is allowing us to live stream the event and bring it to many folks who are not able to be here in person. I'd also like to thank Karen Nayland for her work with communications, getting the word out about the symposium. And many thanks to Daryl Yeager, our one-man IT shop, for all his work. Again, many thanks, pardon me, for all of you for being here today. Please enjoy your day at Mizzou Law.
Hey, good morning. My name is Kenyon Briggs, and I am the editor-in-chief of the Business, Entrepreneurship, and Tax Law Review, and I would like to echo Professor Dean Litton and say thank you and welcome for everybody being here. I know yesterday the weather was a little iffy. We didn't know if some planes were going to touch down. We didn't know if some people were going to make the drive in, but it all worked out. We're all here. Thank you so much. I just wanted to speak on behalf of the students of BETR, the Business, Entrepreneurship, and Tax Law Review, and just say a few words about what the journal does and kind of set the tone before we get going. My name is Kenyon Briggs. I am a 3L, and I'm originally from Kansas City, Missouri. I have written 2 articles when I was an associate member on BETR. Both of them cited Professor Tom Lambert's book. So this is actually kind of a fun full circle moment for me where I remember as soon as I started writing my article, he came out with this lovely book. I didn't know if you knew he wrote a book. There it is. It's on the pamphlets. It's great. You should all check it out. And so I remember working with Professor Lambert, talking about what his ideas of regulation, what some of the things policymakers should keep in mind when they approach these new problems that we haven't ever experienced before. After writing my articles, I had such an amazing time writing my articles. I knew I wanted to step into the editor-in-chief role and help the next wave of associate members identify new problems in the world to tackle. I am confident that BETR, we had a team meeting last week, and I said, above everything else that the journal does, I think we publish articles that help solve the world's problems. We published an article last semester about how the scenes of fair doctrine of copyright law, I'm sure everyone is well aware of what that is, how it helps promote stereotyping in all aspects of the media. And problems we didn't even know existed, she proposed ways on how to fix it. We published, from our last symposium, we had speakers come and talk about how First Amendment doctrines and the colloquial term of fake news, how can we combat these fake news stories going out into the world when the First Amendment says that that's protected speech, and she proposed solutions on how to improve that. We have published articles on how to help improve sharing economy businesses like Airbnb. We've published articles on how to help victims of domestic abuse. We are publishing articles currently on how to help increase a lack of blood donations for people who need blood in hospitals. We're publishing articles on how to increase the use of renewable energy. At our core, journal with the best pun, we make the world better with our articles. That's what, yeah, thank you. Finally, I know the 3 L's in the room, all the students who are dressed up, we're on the journal. As the 3 L's in the room, we're about to graduate, and we are going to hopefully be going on to greener pastures. But the next group of associate members coming in are very excited to take the articles that our speakers are going to be writing and publish those in our next issue. Because BETR, as is the youngest journal of 3 at the law school, we have a lot of potential. We publish a lot of very exciting articles, and I'm sure that the next editorial team is going to be very happy to work with you. The last thing I want to say is thank you to CIPE, the Center for Intellectual Property and Entrepreneurship. BETR is the brainchild of a lot of culminations, but our organization that oversees BETR is CIPE. Professor Sam Hallaby is here, so thank you. And the last thing I really want to say is this event would not have happened if it wasn't for Larissa Tiller. Larissa Tiller is our lead articles editor. I was telling my team members before, I said if the day seems like it's going fine, you don't know how much work went in to make this happen. Larissa Tiller, Professor Cecil, Professor Lambert got the speakers organized. So much work has gone in to make this happen. I'm so excited to just sit back and watch it all happen. So I think Professor Lambert is going to take it away.
I don't know how to do this. All right. Wow, this is really loud. Can we turn it in? Oh, there we go. It's much better. Very happy to have so many people here today, and should not be allowed to engage in proprietary trading practices. They can't buy and sell securities for profit or federally insured banks. And there's a lot of truth to that. I mean, these banks are basically gambling with the public's money. So you want to make sure that they're not just taking gambles for profit for themselves and that they, poorly they rely on the public's picks for trading. That made a lot of sense at the time. But the Wall Street journal, no offense, Places to drink here in the Broadway area. And it's very busy on, say, a Saturday night. Right? So it's dangerous. You know, people are driving when they shouldn't be driving. There are people that are staggering out into the street. It's a mess, and there's a very heavy police presence in Columbia in order to deal with these problems. So, you know, suppose that this is, you know, you are walking down Broadway on a Saturday night, and you know that there are people that are driving that shouldn't be, et cetera. And you think, well, I want to cross to the other side of Broadway. It's a really busy street, lots of bad traffic right now. It's dangerous. You know, people are driving. I want to protect myself from getting hit by a car. Out into the street. Right. Now there's there's a very heavy police presence in Columbia in order to deal down at with the far end of Broadway. They'll take you all the way over the road. You are walking down. If you go across Broadway that crosswalk, you're obviously in no danger of getting hit by a car. But it's a hike to get down there. Right, so this may be what you're thinking. My expected loss from jaywalking across Broadway is $20. That's the probability that I'm going to get hit times the loss that will occur if I, in fact, do get hit. This is sort of the old hand formula from torts. I could eliminate this risk. My expected loss would go from 20 to 0 if I go down to that crosswalk, but it's a pain to go down to the crosswalk. It's going to cost me $3 of effort to go down to that crosswalk. Is walking to the overpass cost justified? Well, if you look at this, you might say, yes, that's totally cost justified. I'm going to spend $3 of effort, to get a benefit of $20. I reduce my risk from 20 to 0. That's awesome. $17 of benefit. Of course I should do that. But of course, to answer the question of whether walking to the overpass is cost justified, you got to know more than just this. You got to know what else you might be able to do. So you could, of course, just go to the corner and wait for the light to change and cross the street. Now, if you do that, you're not going to reduce your risk down to 0 because there are some people that don't follow the stop lights, you know. On a Saturday night, some drunk people try to run through that yellow light when it's no longer yellow, and you could get hurt. So you're not going to reduce your risk from 20 to 0, but you could reduce the expected loss of crossing from 20 to, say, 1. You know, it's less likely that you're going to get hit. Now, the cost to cross at the corner is significantly less than the cost of going all the way down to the overpass. It's a long way down there. Let's say it would cost you just $1 to go to the crosswalk and wait for the light to change. Now, ask yourself, is walking to the overpass cost justified? It's not. Here's why. If you go to the corner and cross, you're going to get $19 worth of benefit. Basically, you reduce your expected loss from 20 to 1, $19 of benefit. It's going to cost you $1 to get that benefit. So your net benefit is 18. If you go all the way to the crosswalk, your net benefit is going to be 17. If you think about it, the added benefit that you get from going not to the crosswalk, but instead all the way to the overpass is $1. You reduce your risk from $1 to 0 if you go all the way over. But it's going to cost you $2 to get that added benefit. The difference between the $1 cost of crossing at the crosswalk and the $3 cost of going to the overpass. It doesn't make sense to spend $3 to get a benefit of $1. Right? So here's the point. When we're thinking about regulation, you shouldn't just take a snapshot of one regulatory approach and ask, are the out-of-pocket costs and the business losses, I mean, the losses from not being able to engage in transactions, et cetera, are those costs less than the benefits? If so, then this makes sense. Now, you have to think about other things that you might be able to do that would create greater value. Right? So here's the way that economists would think about this. As you get more and more restricted with whatever approach that you're using, regulatory approach that you're using, the added benefit, the incremental benefit you get from more and more restrictiveness tends to drop over time. And the greater restrictiveness, every unit of restrictiveness, tends to get more and more costly as you go forward. Ideally, what we'd want to do is come up with a policy that is, you know, at the intersection of those two curves. If you go beyond that, then you're actually incurring greater cost than incremental benefit. You always want to you know, get to the point where your marginal cost and your marginal benefits are equal. You know, and this comes up all the time in regulatory decision making. You take the market failure of information asymmetry that can cause what economists call lemons problems. And basically, information asymmetry exists, you know, when the two parties to some transaction have wildly different information about the quality of the thing being sold. So I could explain why that leads to markets not working well, but I won't do that right now. The point is, we need to deal with this information asymmetry that leads to systematically low quality offerings. There's several things that we could do. We could just impose minimum quality standards and say, look, the symptom that we're worried about is that all the high quality offerings are being driven out of the market because of this information asymmetry. So we're going to have minimum quality standards. Or we could mandate disclosure. We're not going to mandate the quality of what's being sold in this market, but we're going to require the seller who's informationally advantaged to provide information to the buyer who doesn't have the same informational advantage. That's a less restrictive approach. You could go even less restrictive and have voluntary disclosure schemes that are facilitated in some way by the government. So there are lots of different things that you could do, and what you always need to be thinking is, does the incremental restrictiveness, this little bit of extra restrictiveness, is it worth it? Is it getting us as much benefit as it costs to go that added level of restrictiveness? All right. Tip number 4. Once policymakers have diagnosed the disease, laid out the range of remedies, and sort of figured out what's optimal here, they have to start thinking about side effects. You know, if we adopt this remedy, what are the adverse consequences that will arise? I'm going to hit a couple of side effects that you always need to ask about, I think, as a regulatory decision maker. One of these is losses that occur from what we might call the knowledge problem. Students who've taken my business organizations course, this will be familiar to. I make students every semester read this article by F.A. Hayek, The Use of Knowledge in Society. And then Hayek's point in that piece was that central economic planning is likely to fail because the economic planners don't have the information they need to allocate resources efficiently. That information is not given to a single mind, the regulator. And so he argues for having sort of market-based processes, et cetera, to allocate resources more efficiently. Well, if you think about it, regulation is a form of central planning. And so the regulator is always going to face some sort of constraints on his or her knowledge. There's two aspects to this knowledge problem I want to hit really quickly. One is the knowledge deficiency with respect to local facts and circumstances, including the preferences of consumers and other people being regulated. Regulators, when they're crafting the rule, often don't know what they need to know to ensure that they're adopting a rule that's going to allocate resources efficiently. So let me give you a couple of examples. The Sarbanes-Oxley Act that was adopted in, I think, 2002 in the wake of the WorldCom and Enron debacles included a provision called Section 404 that required publicly traded companies to have internal controls that were approved by outside auditors. So you've got approved to some outside auditing firm that you've got controls put in place to prevent accounting fraud, et cetera. And all of these companies were subject to the same requirement. And the idea, of course, was that this will create a net benefit for the shareholders of these companies. We'll see a significant reduction in accounting fraud, which is very bad for shareholders in the long run. It decimates companies. Now, that rule, you know, you've got to put in place internal controls, you've got to get them approved by an outside auditor. It did make sense for a lot of companies. An SEC advisory committee found that for companies with revenues greater than $5 billion, the compliance cost of this rule was about 0.06% of their revenues. Not a lot. For companies with less than $100 million in revenue, on the other hand, compliance costs on a percentage basis were 43 times higher. because it's the same absolute cost for a small company and a big company to do this. It makes a lot of sense for the big company to do it, not so much sense for the small company to incur that level of cost. So this was a case where the regulators were putting in place some rule that applies to everybody without having the knowledge of whether it made sense for all these different companies. Another rule from the financial area is the director independence requirement. So the SEC, at the behest of the SEC, the NASDAQ and New York Stock Exchange put in place these rules. They're technically exchange listing regulations, but the SEC is behind them, that require for publicly traded companies that there be a majority of outside independent directors on the board. And the idea here, of course, is that outside directors will better monitor managers than inside directors who are basically monitoring themselves. So we'll get fewer corporate scandals, less waste at the company, et cetera. Now, that seems to make sense until you account for the fact that boards of directors at different corporations do very different things. I mean, boards are charged with two primary tasks. One is to monitor management and make sure that managers are doing the right thing and punish them when they're not and hire new people and all that kind of stuff. The director independence requirement makes a lot of sense in terms of this monitoring function of the board. On the other hand, boards of directors manage the business. In many companies, the boards are the ones that really make the strategic decisions for the company. Now, to make the best strategic decisions for the company, you need to know a lot about that company's business. Inside directors tend to know more. All right, so this rule makes sense for for boards that are more focused on monitoring, but it doesn't make sense for boards that are more focused on management. And different corporations have their boards do different things because they have different needs. The regulator is not in a position to know for all corporations, what's the optimal mix of inside versus outside directors. One last example here, I mentioned preferences. A lot of times regulation has the effect of thwarting transactions that people would like to enter into. We think there's something harmful about those transactions, so we're not going to allow them to occur. Now, this assumes that the regulator has some sense of what people really in their heart of hearts want, or what would really leave them best off. So if I want to get a will prepared, say I want to get my will done, and I know someone who has a lot of experience with trusts and estates, not a lawyer, but they've worked for a bank, as an executor of a trust or something like that. They've got some significant experience, and I say, will you draft this will for me? I'm not allowed to do that, right? I have to hire somebody that, they can't charge me for drafting the will. I guess that would be unlicensed practice of law. I'm not sure if that's right or not. We've got legal experts here who can, but just go with this. I am required to hire somebody who knows about commercial paper and criminal procedure and the rules of evidence. And I can only hire a fully licensed lawyer who's passed the bar and learned about a lot of stuff that I don't really care that much about, right? So it might be that I would like to hire this guy who has a little will preparing business on the side, and it's cheap because he hasn't had to go through all the rigmarole of becoming a licensed lawyer. I'm not allowed to do that. That's sort of thwarting a win-win transaction. My favorite example of this from the securities arena is with Apple, right? When Apple, under the federal securities laws, the SEC does not engage in merits review. A merits review would be when the commission looks to see, is this financial product that's being sold to the public of high quality? Is it too risky? Only if it's, of a certain level of risk and whatever, are we going to allow it to be sold? The SEC doesn't do that. Instead, they've dealt with this issue of information asymmetry, that's the market failure there, by mandating disclosure. So we're not going to get into the merits of the thing being sold, but you have to provide a lot of information about the thing that you're selling. A lot of states, though, go further in their securities rules, and they have some sort of merits review, right? So Massachusetts is one of those states. When Apple did its IPO in 1980, 1981 or two, early 80s, the Commonwealth of Massachusetts decided, you know, this Apple stock is too risky for the people of the Commonwealth. We are not going to allow our citizens to buy into this. Now, they were imposing their will on the citizens of the Commonwealth of Massachusetts, assuming that they knew what these people's preferences were with respect to risk. And, you know, they made a giant mistake there. So, knowledge problem with respect to local facts, circumstances, and preferences is important. Another aspect of the knowledge problem that I think is important is to recognize that we're pretty bad with predictions, right? So when the regulator is saying, I'm going to put in place a rule to achieve some social outcome that I'm happy with, you got to be pretty sure that the rule is actually going to do what you think it's going to do. And oftentimes regulators really screw up here. So I'll give you a couple of examples. I'm talking a lot about securities and financial markets because other than Commissioner Peirce, we're not really talking much about that. So this is the securities section of our presentation today. The SEC in the last few years has put in place two rules designed to sort of achieve what some people think is a socially desirable outcome. One is this conflict minerals rule. And it says that companies that use certain minerals that are produced in war-torn regions of Africa have to disclose to their investors the supply stream. Where is it that you get that mineral, et cetera, so that investors can, you know, basically punish companies that are doing business with warlords. Right? That was the idea of the conflict minerals rule. The SEC also put in place a rule called the pay equity rule. In the pay equity rule, corporations must disclose in a ratio form how the median pay of their workforce compares to the pay of the CEO. And the idea here is to put some pressure on companies to reduce the vast discrepancy between what the CEO makes and what the workers make. Now, you know, those are laudable goals, stopping warlords and reducing income inequality. But you got to think about how these rules are actually going to work in the real world. The conflict minerals rule has been devastating to parts of Africa. There's a great piece in the New York Times called How Congress Devastated the Congo. And basically what happened with this rule is that the mining jobs disappeared. I mean, companies decide, okay, we got to make sure that we don't get our minerals from this part of Africa, so we're going to get them elsewhere. And so the mining jobs disappeared. The mines kind of went out of business. The warlords didn't cease to exist. They just had to find a new source of income. So they get that by looting villages. Right? With the pay equity rule, the result has been, this is pretty preliminary, but preliminary results suggest that companies are now reducing their employment of low-wage workers and outsourcing those jobs to foreign contractors whose working conditions they can't control. That helps them, you know, with their pay equity ratio. So, you know, when you engage in excessive social engineering, you got to know a lot to know how this thing is actually going to work out. So, acknowledge knowledge limitations. Tip number 5. Look for the bootleggers behind the Baptists. I gave a version of this talk this summer at the Country Club of Missouri, of all places. And someone came up after the talk and was very offended because he said I'm a Baptist and I'm offended by that. I'm like, this is not an anti-Baptist thing. In fact, the Baptists are kind of the good people. So here's what I'm talking about with bootleggers and Baptists. This is a phrase that was coined by economist Bruce Yandel to describe the dynamic of having sort of a politically palatable group, politically sympathetic group, lobby for and get some sort of regulation that actually benefits economically another group that is not politically palatable. Right? So if you go back to prohibition, the two groups that were most in favor of prohibition back in the day were the Baptists, because drinking is sinful and creates all sorts of social problems. They're the good guys. And the bootleggers. They benefited from prohibition because they controlled the supply of illegal liquor and could make more money if liquor was illegal. Right? So the bootleggers go and get them some Baptists to be the frontmen for their regulatory campaign. You see this all the time with regulation. The best examples are with occupational licensure. We've seen this explosion of licensure requirements for occupations, many of which are not traditional professions, haven't been licensed in the past, and every time one of the regimes is put in place, there's some group that comes forward and says, this occupation is dangerous. All these bad things can happen. We have to have some standards here on who's allowed to engage in this occupation and who's not. And they tell very compelling stories, and then they get a rule put in place that ends up benefiting the incumbent providers of whatever the service is. They can charge higher rates now because it's hard to enter into that market. So a recent study of occupational licensure looked at 102 non-professional licensed occupations. So not doctors and lawyers, but just professions that have not traditionally been licensed but now are. So in Louisiana, it was florists. It's been African hair braiders in a lot of places, including Missouri until recently. What the study found that was of those 102 occupations, only 15 of them were subject to licensure in 40 or more states. Right? So, there are plenty of states where the occupation at issue is not licensed. On average, an occupation was subject to licensure in only 22 states. So more than half the states weren't licensing this particular occupation. The occupations worked fine in states that didn't require licensure. It doesn't seem like we need these regimes, but they do benefit groups that have a lot of political power. The study also found these huge disparities in licensure regimes. So manicurists, 10 states require at least 120 days of training for a manicurist. Iowa requires 9. Alaska requires 4. You can get a decent manicure in Anchorage. Your fingers will not fall off, all right? The degree of training that was required seems totally inconsistent with the danger of the occupation. So the average days of education and experience that's required for an EMT, emergency medical technician, is that right, is 33. That's the average number of days. For an interior designer, lots of states require interior designers to have a license. The average days of education and experience required is 2,190. That makes no sense. It makes perfect sense if you think about the fact that this is being controlled by the bootleggers and the Baptists are the front people. All right, last thing, tip number 6. Remember innovation. There's 3 very quick points here. Number 1, innovation may obviate the need for regulation. I think a great example of this, well, I'll ask you. 10 years ago, if you had been suppose you were going to a new city for a conference, and you learn that there's a big convention in the city at the same time, right? So the hotels are all sold out, and you're worried about getting a cab because people are going all over the place because of this other convention. Suppose I said to you, oh, it's okay. There are lots of people that are driving around in the city, and I'm sure that somebody would pick you up in his car and drive you to wherever you need to get. Oh, and don't worry about the fact that there's not any hotel rooms because lots of people in the city have extra bedrooms. I'm sure someone would let you stay in their bedroom for a small price. If I had said that to you, you would have said, you are nuts. You're crazy. I'm not going to do that. And that would have made perfect sense. anybody offering you a ride in their car or a stay in their room in those days is probably a crazy person, and you don't want to stay, you don't want to take advantage of their offering. Right? So you rationally assumed the only options out there are low quality options, lemons. Right? This is what happens when you have vast information asymmetry in a market. We get what's called a market for lemons, and all the high quality offerings are driven out of the market because people who are providing them can't command a sufficient price to justify making the offering available. And so to respond to that, we have had in place traditionally all sorts of licensure regimes. We had licensure requirements for cabs. You had to get a medallion. We've got all sorts of licensure requirements for people who provide lodging, hotel licensures and all that kind of stuff. But of course, you know what happened. Technology intervened. We came up with a different way to level the informational playing field, this reciprocal rating system that Uber and Airbnb have, allow people to basically make credible disclosures about the quality of their offering, and it's totally facilitated a market and obviated a great deal of the need for regulation in this particular area. So that's just one example, but we need to keep our eye open to that, the regulations, how innovation can obviate the need for regulation. Innovation is a key driver of economic growth. A lot of regulatory regimes require people to go to the government and ask permission to do stuff. I won't talk too much about this because I think Jerry is going to talk about net neutrality. No? Yeah. Title II? Okay. So the FCC recently got rid of its Title II rule that involved a lot of this. I mean, at least it had the potential to require sort of this mother may I approach to internet service providers and others operating in that scheme. So I'll let him talk about that. Last thing, it's okay even for regulators to innovate. Great story about regulatory intervention or innovation was Ronald Coase. Many of you know of him. Anybody who's taken my class knows of him. The guy behind the Coase theorem. Ronald Coase suggested years ago that the FCC should start auctioning rights to the radio spectrum. Give people a property right in that. That would be a more efficient way to do this than to have the system that we had in place where we had these hearings and the FCC would decide who was best at operating this particular frequency, license for this particular frequency. When he suggested this, he was just completely ridiculed. He appeared before the FCC to testify about it, and the first question that was asked of him was this: "Tell us, Professor, is this all a big joke?" All right. Well, guess what happened? Eventually, the system that was in place there at the FCC became just unwieldy, and we went to the Coasean system, and it's been just hugely successful. Regulators sometimes get sort of locked into the status quo, and I want us to think today about how they might break out of that and innovate a little bit. All right, thank you very much. We've got a little break now till 10:10, and we will then hear from our first panel on regulatory substance. Thanks. for some crosstalk between our panelists and also questions. So please be thinking about your questions. Our first presenter will be Dr. Jerry Ellig, who's a research professor at George Washington University Regulatory Studies Center. Jerry has had a number of important roles in the government. He, as I mentioned, served as the chief economist for the Federal Communications Commission in 2017, 2018, so not very long ago. He also has been at the Federal Trade Commission, which I think is interesting. Those two agencies are tasked with considering different types of market failure. So it'll be interesting to hear from him. He was Deputy Director and Acting Director of the Office of Policy Planning at the FTC. And then he's also been an advisor to Congress. He was Senior Economist for the Joint Economic Committee of the U.S. Congress. An interesting fact that I learned about Jerry is that he is a connoisseur of tiki bars. And I thought they were all the same, but apparently not true. So his wife actually accompanied him on this trip. She was at my house last night, and they are visiting several tiki bars in the state of Missouri. I'll try to get the details on what's good, et cetera, pass that along. Next, we're going to hear from Gus Hurwitz. Gus is a professor at the University of Nebraska Law School. He was identified recently by the National Law Journal as a cybersecurity and data privacy trailblazer, which is exciting.
Very.
He is the co-director of the Space, Cyber, and Telecommunications Law program at Nebraska. But don't get excited. He's in charge of the cyber and telecommunications aspect, not the space aspect. I think space regulation would have been really fun, but we'll have to get your colleague to come talk about that sometime. Gus has been at George Mason as a visiting professor of law. He was also at Penn as a research fellow in the Law School Center for Technology, Innovation, and Competition, and a trial lawyer with the Department of Justice Antitrust Division in DC. He's also worked at Los Alamos National Lab, which is pretty fascinating. And he's a graduate of what we sometimes refer to as that law school than which none greater can be conceived, the University of Chicago Law School. Also has a degree in economics from George Mason and his BA from St. John's College. And then finally, we have my colleague, one of my favorite colleagues, not that I have favorites, but I do, she's one of them. Professor Erica Litzen. For the law students in here, if you have not taken one of Professor Litzen's courses, you must. I have been hearing from students that they're among the most valuable classes that they've taken in law school. She's a little tough, but it's worth it. And she is stealing some of my proteges. I'll get these students that I convinced they want to go into antitrust law, and then they take her class and they want to be food and drug lawyers, so we're sort of arm wrestling a little bit. Professor Litzen came to Mizzou from Covington and Burling in DC, where she was a partner for 8 years and was heavily involved in drug and device regulation issues. She's been very involved in the crafting of drug regulation. Every major amendment to the Federal Food, Drug, and Cosmetic Act between 1997 and 2014. She was very involved in the development of the statute on biologics, which I only recently learned about. I had the pleasure of going to a conference in DC in the fall on prescription drug pricing, and Erica was at the conference, and I got to see firsthand what a rock star she is. Everybody wanted to talk to Erica, and it's really exciting when you see one of your colleagues in their element. She's a big deal. I was worried that she was going to talk about her latest paper because she's been talking to me about it quite a bit. It is on...
I am talking about that paper.
Okay. It's on fecal microbiota transfer. I'll let you figure out what that is. And it's disgusting, and she's been talking about it a lot. But she's not going to focus on the details of the technology, I think.
We
today.
talk about it over meals.
Okay, right. Yeah, that's for lunch. In any event,
Will there be PowerPoint?
Right. The goal here is to have each of these people talk about, what do we need to do in my field and what do we need to be careful about? And let's see if we can identify some common threads. So with that said, we will begin here with Jerry.
Okay, is this mic in the right place to work all right?
I think that's fine.
Okay, great. All right, well, gee, I feel like I ought to start with fecal-biotic transfer because I do have some experience with this. I work in an office in my house most of the time, and we have a geriatric rabbit who hops around in my office all the time, and there's plenty of that. There's plenty of that going around. But no, I'll stick to the topic that I was asked to talk about. Now, Tom mentions he wrote this book in part because he was concerned that a lot of the legal curriculum on regulation tends to focus more on process and less on substantive analysis of regulations. And I think that is very aptly described by a great comment from a longtime friend and colleague of mine, Richard Williams. Richard's a PhD economist. He's now retired, but he spent 27 years at the Food and Drug Administration. And he said, yeah, when I was at the FDA, I wanted them to make decisions on regulations based on economic analysis, and all these attorneys kept deferring to this Irish guy, Will O'Congress. I'm not going to talk about Will O'Congress because the topic I'm going to talk about, which is the Federal Communications Commission's Restoring Internet Freedom Order, was issued under the public interest standard in the Communication Act, which pretty much gives the FCC the freedom to do almost whatever three commissioners decide they want to do. So Will O'Congress is not such a big deal there, but substantive analysis is. What I want to talk about is briefly how that order actually, the economic analysis in that order actually illustrates a number of the key principles that Tom talks about in this book, namely, diagnosing the cause of the problem, considering alternative solutions to the problem, recognizing various kinds of public choice problems or government imperfections, or what he referred to on the slide as the Bootlegger and Baptist problems, and also recognizing how regulation may affect innovation. All right, and as I said, the example I'm going to use is the Restoring Internet Freedom Order. Since I was working at the FCC as chief economist, I got to basically oversee the economic analysis that went into that order. So there are a lot of parallels with the principles in Tom's book because I tend to think about regulation the same way. And a little bit of an inside story, the advisor in the chairman's office who was responsible for that particular item also happens to be a PhD economist who taught benefit cost analysis at Johns Hopkins. So yeah, there was a decent amount of economics in the 2017 order. Well, some people, I call it the 2017 order because the commission approved it in December 2017, came out in the Federal Register in 2018. So 2017, 2018, same thing. But yeah, there was a lot of economics woven into that order in contrast to the previous order that imposed the net neutrality regulations. But there were four major substantive decisions in that order that I want to touch on briefly that illustrate some of the principles Tom talks about in this book. One was what the FCC did on the issue of blocking and throttling. The second was what the FCC did on the issue of paid prioritization for internet service by local internet service providers. The third is what the FCC decided on something that was called the General Conduct Rule, which was a rule adopted in 2015 that essentially said, well, also prohibited is any business conduct by internet service providers that the commission decides in the future might be a problem. And then the final substantive decision is this decision to reclassify broadband internet service from Title II of the Communications Act, which essentially treated companies as common carriers and potentially imposed all kinds of regulations related to public utilities, including price regulation, reclassified broadband back to Title I of the Communications Act, where they're more lightly regulated and a lot of utility-type regulations could not be imposed. Let's see if I can put this here and see it. Ah, perfect. Okay. All right. So, first of all, the issue of blocking and throttling. The 2015 net neutrality order prohibited internet service providers from engaging in blocking content, preventing the ultimate subscriber from seeing certain types of content online, and also prohibited them from throttling, slowing down particular content. Now, there's economic research on this. The economic research is all pure economic theory, not empirical, because there haven't been many instances of blocking or throttling for economists to study. And the economic research on this in peer-reviewed journals pretty much shows that, yeah, blocking and throttling can ultimately harm the customer in various kinds of ways. But as an empirical matter, it's been rare. There have been very few documented instances where internet service providers actually engaged in blocking and throttling. There's been an awful lot of, well, they have the power to do this, therefore we need to prohibit them from doing it because they might do it. In the 2015 order that imposed the net neutrality regulations and outlawed blocking and throttling, there were just 4 documented cases cited. One was called Madison River, which involved a local telephone company that was preventing customers from using voice over internet. Arguably, that could have been pursued as an antitrust case because it was a company trying to protect its monopoly on local voice service. There was a case involving Comcast blocking or throttling or delaying, depending on your interpretation, customers' use of a service called BitTorrent, which used a lot of bandwidth all at the same time. There was a case where AT&T Wireless prevented customers from using FaceTime for 3 months if they were on unlimited plans in 2012, and then after 3 months they allowed it. And then there was another case involving Comcast and an Xbox application used on Comcast, but it turned out that this wasn't even provided by Comcast broadband service. This was like a separate piece of the cable tube that was being used to provide the Xbox application. So these things have been pretty rare. And so the interesting economic question is, well, why has blocking and throttling been rare? And there are some pretty straightforward answers. One is that for an awful lot of consumers, openness is a pretty darn important feature of your internet service. I mean, when you decide to subscribe to broadband service, one of the reasons you want to get it is because you can reach pretty much anything, and you don't even know for sure what you're going to want to reach and what you're not going to want to reach. So there's a very strong consumer preference for openness, which means that if an internet service provider starts blocking or throttling content, they could lose customers. People either decide not to subscribe altogether, or they go to a competitor. And you might say, competitor, what the heck is that in broadband? Well, the FCC's order went and looked at some of the FCC's own statistics on competition in broadband, found that 97% of Americans live in census blocks that have access to 3 or more broadband providers. Now that includes some things like satellite that might not be great substitutes. So if you narrow it down to wireline broadband providers, you find that at that time in 2017, or the most recent statistics, which were from 2016, showed that between 68 and 76% of Americans lived in census blocks with 2 or more wireline internet service providers that were offering speeds greater than or equal to 10 megabytes per second. By the way, in 2017, those figures just came out. We're now up to 83% of Americans are in census blocks that have 2 or more broadband providers offering, wired broadband providers offering speeds greater than or equal to 10 megabytes per second. There are also wireless carriers, 4 national wireless carriers, a competitive fringe of local wireless carriers. 1 out of 5 households only use mobile as their broadband access, not your traditional wired internet service provider. And there's also 5th-generation broadband being implemented on the horizon by wireless companies, which is faster and is going to make wireless an even better substitute for wireline. Empirical research on capital-intensive industries, you might ask, well, 2 competitors, big deal. Why does that matter? Don't you need a lot of competitors? Empirical research on capital-intensive industries tends to show that having at least 2 competitors is pretty darn important for reducing prices. Kind of makes sense. Having at least 2 competitors is pretty darn important. Having a strong number 3 can often be pretty important, and adding a 4th competitor often has little additional effect on prices. Because in a highly capital-intensive industry, firms have incentives to try to cut prices almost all the way down to the incremental cost of getting the additional subscriber, because if they charge just a little more than the incremental cost, then they get to earn some profit on the subscriber to help cover their fixed costs. So there's pretty strong incentives for firms that sink a lot of capital into the ground to compete pretty heavily. So from this, the FCC concluded that the combination of a strong consumer preference for openness, material competition, not perfect competition in the textbook sense, but clearly there is material competition that exercises constraints on internet service provider behavior, and the application of antitrust laws and the application of consumer protection laws are probably sufficient to guarantee that you're going to get openness whenever customers want it. And that was the reason that the FCC decided we don't need a separate additional prohibition on blocking and throttling. When and if it does occur in a way that harms consumers, antitrust is probably adequate to deal with it. And the major internet service providers have all publicly committed not to block or throttle, which means that if one of those firms does turn around and do it, then they can be prosecuted under the Federal Trade Commission's general prohibition on misleading, false and misleading business practices for essentially engaging in fraud, saying that their system is open, but then they don't provide an open system. And there's not testimony, comments from the Federal Trade Commission in the record essentially saying, yeah, those public commitments are enforceable under the FTC Act if the company goes back on it. Okay, second, paid prioritization. The issue there is whether an internet service provider could charge some content provider like Netflix or some other provider of video a premium price to prioritize their content over other folks' content. And there's economic research on this. There's probably a couple of dozen papers in peer-reviewed journals that look at this issue. Again, because paid prioritization has not been tried in practice, the economic analysis is all purely theoretical. And what the theoretical modeling demonstrates is that under plausible condition, paid prioritization by an internet service provider can either increase or decrease consumer welfare. So the unequivocal answer from theoretical economic research is it depends on the facts and circumstances. There may be cases, for example, such as you have a new competitor wants to get into the video business. The best way that they can offer a quality of streaming video service comparable to the established firms like Netflix and Hulu would be to go to the local ISPs and say, hey, we'll pay you something in order to give us priority so that our video streams uninterrupted. The big guys who offer video services accomplish that today by caching their video in data centers much closer to the viewer. I don't know if you know this, but if you're watching a video on Netflix, that's not streaming over the public internet from California. That's going to be a copy that you're watching is parked in a data center a lot closer to you, and it just makes the last little hop to your house so you can see it. Netflix is able and allowed to do that because they've essentially constructed their own network outside of the internet to get stuff from them to your local internet service provider. And that's all perfectly legal because it doesn't involve Netflix paying the internet service provider for prioritization. They just build their own network around the internet and pay other firms who aren't part of the public internet to do it for them. So if you're a big guy, you can do that. If you're a startup, you might not be able to, and so you might be able to break into the market more easily if you're allowed to do that kind of thing. That's one way paid prioritization might actually benefit consumers by allowing additional competitive options. Well, the FCC concluded, from the existing economic research that if the economic research unequivocally shows that paid prioritization could either benefit consumers or could harm consumers, then an outright ban on paid prioritization in all circumstances, which is what was adopted in 2015, couldn't possibly be the right rule. And so, what the FCC opted to do is first off require disclosure of whether your internet company engages in paid prioritization or not. So if they allow, if you're the internet service provider does have some kind of a deal with somebody for paid prioritization, they have to disclose it publicly so that you know whether your internet company is doing it or not. And so the antitrust enforcement agencies know whether the local internet company is doing this or not. And it turns out that the antitrust rule of reason is pretty well crafted to deal with precisely these kinds of business practices that might in some cases harm consumer welfare and might in other cases improve consumer welfare. So again, the FCC decided that the way that antitrust works is a much more flexible and probably optimal way to deal with this business practice rather than trying to deal with it with a per se prohibition. Okay. There was a third thing adopted as part of the 2015 order called the General Conduct Rule that essentially said, okay, there are going to be, aside from blocking and throttling and aside from paid prioritization, there are going to be other things that are going to be prohibited under this rule, and right now we're not going to tell you what they are. Instead, what we will do is in the future examine business practices as they arise according to a non-exhaustive list of criteria that are not necessarily all based in economics. And so the FCC said, we will evaluate business practices in the future that we think might be questionable based on a bunch of criteria like if they allow some kind of end user control of the practice. That's a positive. We will look at the effect on firms offering services that compete with the internet service provider. We will look at whether there was unfairness or deception. We will look at the effects on innovation, investment, and deployment of broadband. We will look at effects on free expression. We will look at whether the business practice is application agnostic. We will look at whether the business practice is rooted in best practices or technical standards available from open, broadly representative, and independent internet engineering or standards organizations. And by the way, this list is non-exhaustive. So anything an internet service provider might do that might run afoul of any of those issues is potentially prohibited when the FCC goes to look at it. You can imagine how this might be a little bit problematic if you have internet service providers thinking of offering new types of services or new types of business arrangements. The only business practice that was investigated under this standard by the FCC was something that in the industry is known as zero rating, which was basically a deal offered by several of the wireless internet service providers who essentially told customers, hey, on your phones, if you let us slow down the speed of video, certain types of video, you can watch that video for free and not have it count against your data allowance. The FCC investigated this, ended up issuing an inconclusive report that was later withdrawn. But the upshot of it is that the only business practice that was ever investigated under this rule was a business practice that gave the customer something for free. This too was a type of practice and a type of issue that the FCC looked at and said, yeah, you know, maybe instead of issuing a non-exclusive list of criteria and saying you might be in violation of this rule at some time in the future, we ought to say that kind of behavior ought to be dealt with under antitrust, where, you know, you've got the flexibility to look at new kinds of business practices, but you also have a long line of established antitrust precedent that helps companies figure out what kind of things are likely to be okay and what kind of things are not likely to be okay. Okay, then finally, the fourth substantive issue was the reclassification of broadband under Title II instead of Title I. There was even a song about this. No, I always said that there were the three things I was proudest of working as chief economist at the FCC was working on the Internet Freedom Order, working on the creation of the new Office of Economics and Analytics, which reorganized the economists at the FCC into one entity where they're managed by other economists instead of reporting to the attorneys who write the regulations, and then they have to tell their boss whether their boss made a good decision or not. And then the third thing was singing with the FCC Christmas carolers, which is a tradition that every year they have a group of folks who do songs that are parodies of the different things that were going on at the commission over the year. And I remember partially the carol about The first title of the Telecom Act has a vibe that is cool and transparent and lax. The second title, heavy-handed and mean, and I don't remember the rest of it, but you get the idea. Okay, so how did the FCC deal with this in the Restoring Internet Freedom Order? Title II regulation under the Telecom Act made broadband eligible to be regulated as a traditional public utility, which meant it made broadband eligible to have, for the FCC to impose restrictions on entry of new competitors, restrictions on exit of existing competitors from particular markets or altogether, restrictions on prices, restrictions on profits, and restrictions on quality. That's the whole panoply of regulations that could be imposed under Title II. Now, when the FCC reclassified broadband under Title II in 2015, the FCC said, okay, we are not going to impose all of those kinds of regulations. We are only saying that broadband is under Title II so that we can have legal authority to impose the regulations we are imposing today, which was the prohibition on blocking and throttling and the various other things that I already talked about. So then the question is, how believable was this commitment by the FCC to only impose the regulations it imposed in 2015 and go no further? So you have a regulator with a commitment problem. And it's well known in economics literature that regulators can often have problems making credible commitments to refrain from regulating in cases when a business has to sink a lot of money into capital with a long life. Because once the investment is made, what's the regulator's incentive? Well, what the heck, let's regulate the prices downward because the investment has already been made, and now we can push the prices down, and we can give people something for free, and we'll be popular. Or we can give people something for a lower price, and we'll be popular. This is a well-known problem in regulatory economics. How can a regulator make a credible commitment not to do that after the investment is made? So, but the economic problem that sets up is, did reclassification of broadband under Title II create a risk that the FCC would do this and hence depress broadband investment? Now, most of the discussion of this focuses on whether broadband investment went down in 1 year from 2015 to 2016 or 2016 to 2017 after the regulation was imposed. That's the wrong question. Broadband investment did go down, but that's really the wrong issue. Because the right issue is, what's the counterfactual? How does broadband investment after the adoption of the Title II regulation compare to what broadband investment would have been if Title II were not adopted? And there were a couple of empirical studies that were useful on this. There was one study that looked at, essentially looked at trends in investment in broadband versus several other comparable industries, and found that after imposition of the 2015 regulations, you had a reduction in investment in broadband compared to the investment trends in the comparable industries. So you have a certain amount of controlling for other factors. There were some other studies by Tom Hazlett, a former chief economist at the FCC, looking at several different instances in the past where broadband had been reclassified from Title II to Title I, and subscribership and investment actually went up. So there was actually a bit of empirical research here that suggests that, yes, Title II does have a depressing effect on broadband investment. And so based on that, the FCC concluded that Title II regulation probably increased the risk premium, reduced investment, and so it would be better to restore broadband's classification under Title I, especially because since the FCC in the order made the other changes to the rules regarding net neutrality, they didn't need to have broadband classified under Title II in order for the new rules to apply, the new rules related to disclosure and some of these other things. So I hope what I managed to do in the amount of time that I've taken out of your morning is give you some idea of how the economic thinking behind the Restoring Internet Freedom Order was actually pretty consistent with some of the principles that Tom said regulators ought to be applying in his book.
we have brought together, or Tom has brought together, folks from a lot of different perspectives to talk about a common challenge, how we regulate complex issues. Too often, the approach that we take is siloed. And who gets filtered into those silos? Those who are interested in those fields. We see this nowhere more than in my main field, law and technology. Who becomes a technology lawyer? Who becomes a law and technology academic? Well, you all know. It's the people who at Thanksgiving dinner, when they come home, they're asked to help figure out how the computers work. We get sorted into this field based upon our technical expertise, not because of any depth of legal thought. Not because we are good at thinking about legal problems, but you go to law school and your professors say, oh, you know the computer stuff. You should go into copyright law. You should do patent law. You should think about the internet stuff. And then if you're really excited about this stuff, you want to work in the policy fields, you become an academic, and you get hired by a faculty who knows nothing about the field. They just know, we need someone to do the tech stuff. You're excited about the tech stuff. You're a new law and technology professor. You don't know anything about regulation or economics or about administrative law or about the First Amendment. You know how to turn on the computer and reinstall Internet Explorer when it doesn't work at Thanksgiving. We need more breaking down of the silos. We need more pure legal thinkers thinking about these hard problems. And we're in a stage of technology, a technological evolution and dependence in our modern society and economy, where we need a cross-silo, transdisciplinary, that's my buzzword of the year, thinking about hard legal problems. We need constitutional theorists, we need regulatory theorists, we need torts theorists, we need criminal theorists, we need all of the traditional legal field theorists coming together thinking, how do these problems that we have experience and expertise in play out in the technical setting? You don't need your systems administrator telling you, well, this is what I think about con law, so this is how the law should address technical issues. So having thrown my field under the bus thoroughly, what the heck is my field? I do telecom, I do internet stuff, I do a lot of administrative law, I do economics, I am increasingly doing a lot of freedom of speech. That's what I'm going to be talking about today. I think Tom was expecting that I would come in and talk about big data platforms and how we regulate them, or maybe privacy or data security. I'm not going to talk about any of that stuff because one of the great things about how I've approached my field is I do everything in order to stay relevant marginally in any way. I'm going to talk about the regulation of speech on social media and technology platforms. And my framing of this discussion to situate it in Tom's broader project is how the way that speech on these platforms occurs is changing how we need to think about foundational regulatory issues and frankly not regulatory in the regulation, administrative agency context, but in the broader legal principles going down to the First Amendment context. What's going on with social media? What's going on with how speech occurs in modern technology? There are two dominant trends I want to use to frame the changing technology of speech. I'm going to frame them in two distinct but related ways. The first way that I'm going to identify these two trends is the increased velocity of speech and the increased disintermediation of speech. What does that mean? It means that more ideas are coming at us more quickly than ever from more directions than ever, and they are coming at us directly. So the example du jour of this is Twitter. You go on Twitter and you're seeing all the news as it's happening from all sorts of sources. You've got no idea who these people tweeting are. You've got no idea where this this tweet that's been retweeted 12,000 times is coming from, but it's been retweeted 12,000 times and Twitter's bringing it to you directly. Or Facebook. Your friends are sharing the news that they're seeing. Who knows what the source is? You know, oh, Jim retweeted this. Sally is commenting on this. This must have some valence to it. There must be some trustworthiness behind this because we're in a peer-to-peer news and information world. we rely less on the traditional gatekeepers and intermediaries. The second way that I'm going to frame this is more economically. The cost of producing and distributing news and information, content, is going down. It has gone down dramatically. And because of those decreasing costs of producing and distributing information going down, the amount of information that we are exposed to is growing exponentially. So we have an exponential increase in the amount of information that we're being asked to process. Over that same period of time, has our ability to process, understand, sort through this information dramatically increased? No. We still have the same brains that we had when James Madison, I choose James Madison advisedly, when he was writing the Federalist Papers. We're roughly as smart as he was, our mental capacities. In fact, go back 2,000, go back 5,000, go back to the Neanderthals. Our mental capacities are not dramatically different today than they were thousands of years ago. We have more knowledge, but in terms of our ability to process, comprehend information, it's grown, if anything, linearly, not exponentially. So, three lenses that I want to use to think about what this means for regulation. So first, what have I done with this framing? I've said something has changed in our speech and information environment. What does that tell us maybe we should do from a regulatory perspective? Keep holding on to the principles that we used for the old setting and say, yes, let's charge ahead and use what worked before to address our current problems? No, that obviously makes no sense. So we need to think laterally. We need to think about what other tools are out there, both to understand what these problems are. So we need to take a step back to first principles and say, what are the challenges, what are the problems that we need to solve, what are the tools that we have to address it, and then we need to survey the landscape for other tools we have. So what is our traditional tool? The traditional American approach to there being a lot of speech that we need to filter through. I'm going to follow quick lateral. I'm going to pick this up and I'm going to come over here. I see a whiteboard. I don't have slides. I'm going to jot a couple things on this whiteboard. So the traditional American approach to filtering through, sorting through ideas is the marketplace of ideas. Bad ideas are going to fail in this marketplace. So Jerry comes up here and spews out a bunch of garbage. How are we going to deal with this? Not to say that Jerry spewed out garbage, words of gold and brilliance, if anything. Well, Tom is going to come up here and say, here's why Jerry's wrong, here are my competing ideas, and a bunch of people in this room are going to say Jerry's better, a bunch are going to say Tom's better. Over time, we're going to argue this out. Jerry's ideas get pushed down, or more, they don't get pushed down, it's just that Tom's ideas rise to the top. The marketplace of ideas sorts out the higher value ideas and places higher value on them, so we adopt and embrace them. That's the marketplace of ideas approach. Well, does that work in our modern information setting? Well, we know the answer to this. We're experiencing it every day. This basic problem is the exponential growth of the amount of information that we're being exposed to. We are placing increasing burdens on the consumers of information to sort through an increasing amount of information. And in fact, what do the producers of that information do? Well, Tom used a really important word. They externalize that the processing function. So increasingly, how does the New York Times compete with BuzzFeed? Well, by adopting the clickbait headline approach. By, if you go back to the antitrust debates of the 1912 election, similar 100 years ago, antitrust was a major issue. If you read the newspapers back then, the articles were really small font, and they would go over many, many pages, and they were detailed, and you'd be expected to sit there and spend an entire hour reading an article just to understand what the debates were. Nowadays, you have the BuzzFeed clickbait article with the headline, FCC destroyed, devastated by intense questioning in Mozilla net neutrality appeal. That's the opinion from, not the opinion, the DC Circuit challenge to the order that Jerry was So to the extent that the intermediaries are trying to compete, first they need to explain, since the consumers of the information are getting both views, they need to explain why the wrong view is wrong. By this point, they've already lost the reader's attention. And then they go on to explain the right view. So what we see in the marketplace of ideas is a traditional race to the bottom, another traditional economic concept, where the news sources, the information sources, the media sources that are going to succeed are the ones that can appeal to our biases as consumers of information. So when we lose this filtering capability, we're going to see an erosion of the marketplace of ideas. Okay, second thing I'm going to put up here. James Madison. I said I used his name advisedly before. So Madison, at the time of the founding, and while we were debating the Bill of Rights and coming up with things like the First Amendment, there was a lot of debate about speech. There was a lot of debate about the role of democracy, factions, the formation of factions, how to protect democracy against the formation of factions, what drives the formation of factions in Madison's view, what drives these challenges to democracy that factions create. Well, it is the rapid embrace of populist ideas by small groups of the community. That is, it's the marketplace of ideas failing. Madison's approach to dealing with this was the structure of government. He thought of our complex federal system with a system of checks and balances, 50 independent states, an electoral college, as a series of circuit breakers designed precisely to slow down the rate at which populist ideas could be translated from factional opinion to policy, regulation, and law. He viewed as a virtue our large population and geography. He viewed this as a way to slow down the rate at which a bad idea or a populist idea could spread, to give other ideas, contrary ideas, the opportunity to enter into the marketplace of ideas and push back. So what is the Madisonian response to this concern about the marketplace of ideas? Well, it's going to be to throw one of our basic First Amendment concepts under the bus. So I'm sure you all have heard the response to bad speech is more speech. From the Madisonian perspective, the response to bad speech is slower speech. We need to slow down the rate of information. Now, I don't know how to do that. I personally am a very strong believer in the importance of the First Amendment. I should say that my comments today do not lead to any regulatory prescription or suggestion. To the extent they do, I expect that they are suggestions that I'm not comfortable with, because I don't want the government saying, well, Twitter's a bad platform, so we're going to slow you down following Madison, and we're going to advance the perspective of the New York Times and traditional media instead. We have knowledge problem issues there. We've got regulatory capture problems issues there. My goal with these comments is to identify problems, not solutions, because we cannot talk about solutions until we understand the problems. That said, there's a third framing of the Madisonian problem that I want to give you. Information theory. This is something I expect many of you have never heard of. Who here has heard of Albert Einstein? Expect a lot of hands. Who here has heard of Claude Shannon? No hands. Okay, so Shannon was widely viewed at Bell Labs as frequently compared unfairly to Albert Einstein. The reason researchers at Bell Labs, they collectively got something like 11 or 13 Nobel Prizes, came up with a transistor, the laser, a radar, all sorts of really great stuff. The reason that they said it was unfair to compare Shannon to Einstein is because Shannon was so much smarter. Shannon came up with this field called information theory that deals with how do we measure how much information is required to encode stuff. Okay, this is really abstract. You can see why he was kind of a brilliant talking megabits per second or 8 bits to a byte. We're talking about terms that Shannon developed. This is how we encode content into digital form. He gave us the modern internet. All digital communications are based upon his theories. And one of the most important things that he developed is the channel capacity theorem, which tells us how much information, meaningful information, can you encode in a channel of finite capacity. So if I give you a 6 megahertz band of spectrum, how many megabits of information can you compress, can you cram into that 6 megahertz channel? And he gave us an equation to talk about this. He developed an entire theory around it. The most important thing to understand is that the amount of the capacity of the channel is proportional to what he calls the signal to noise ratio. So he identifies two separate things, signal and noise. Signals, these are actually both pretty straightforward terms. Signal, my voice. I'm communicating to you, you hear my voice, it is transferring information from me to you. Noise, there's construction going on in the background. Someone is chewing gum loudly or crumpling a paper. That's noise. It is interfering with my signal. The signal to noise ratio tells us two things about capacity. First, if there is noise in the communications channel, it reduces the overall capacity. Second, you can overcome that by doing one of two things. If I want to speak to you in a noisy room, I can do one of two things. I can speak more slowly so that you can make out what I'm saying over the noise. So I can slow down my rate of speech. Madison. The other thing that I can do is I can speak more loudly to overcome that background noise. Now, in a finite bounded channel, what happens if I speak more loudly? Well, my voice becomes noise to whatever the causes of noise are. So in fact, you end up with, my voice becomes noise, so you end up getting more noise as the balance out the channel and overcome my louder signal, which means you're fighting against each other. So speaking more loudly tends to just create more interference, further limiting the capacity of the channel. One of my favorite papers out there has nothing to do with the law. It has to do with human language. There are lots of languages in this world that lots of people speak. Some have a large number of words in a common vocabulary. Some have a relatively small number of words. Some you speak relatively slowly. Some you speak very, very quickly, and it's hard to tell what people are saying unless you're really skilled in the language. This paper studies the information content of a large number of human languages and finds that the information content is roughly constant across all languages that humans speak. If we speak quickly, we tend to be speaking with a larger number of small words that convey less information each, but we're getting more of them. If we speak slowly, we tend to have larger words, each of which convey more information. So what's going on in our brains is roughly constant. This goes back to what I said at the beginning, that we roughly can process the same amount of information today that we could 5,000 years ago. So what does information theory, whoa, that was noise. What does information theory tell us about our modern information economy, where we are being subjected to an exponentially increased amount of information? Well, I need to add one more piece to the story of information theory. If I were speaking to you right now in Japanese, would I be conveying information to you? Would I be conveying signal to you? For most of you, I assume, most of you do not speak Japanese, I assume. If you don't know my language, it's just noise. I'm not conveying signal, it's not noise, until we have agreed upon some common dictionary, some common language. If you don't know what good news is, what the valuable information in this stream of information coming from Twitter, coming through our modern information economy is, it doesn't matter if the New York Times is right, or if BuzzFeed is right, or if Tom's blog posts are right. If you don't know which ones are right, you're not getting signal, you're getting noise.
So until we've developed some common understanding, we're in a situation where we're just increasing the noise floor. Our traditional approach to this has been intermediaries, filters, newspapers, trusted editors. Our modern information economy has dramatically lowered barriers to entry, so we're in a different competitive environment. I'm just going to go back up through this chart, back to the marketplace of ideas. What we have seen is as we've had more voices entering the information economy, more competition, we've increased the noise floor. Even if the same number of good ideas are coming out there, the same amount of truth is coming out there, our ability to interpret them and understand them as signal is limited by noise, which has dramatically decreased our capacity, the capacity of our information channels. So on that note, I've spoken for 2 minutes longer than I had intended. I will sit down.
Okay, so this is the poop paper, but I am not talking about the poop. I showed you how to use it, and now I'm struggling here. I'm presenting the same paper, but I'm using a different example, not the fecal microbiota, because Tom winced every time I mentioned fecal microbiota over our lunches. So I'm switching to a different example. All right. And this is a complete change. It's also going to be a little bit more intensely substantive, I think, but that's my nature. All right, so my topic, broadly speaking, is the drug approval system. But what I'm going to do is I am going to focus on a special problem that drug regulator faces. The problem is that there are thousands of prescription drugs on the market today without approved applications. All of these products are illegal. And the dilemma for the regulator is what to do about them. Now I need to figure out how to move my slides. Okay, let me just tell you very, very briefly how conventional drug development works. All right, there are a few people in here who've had my class. The rest of you, this may be new. Researchers identify a promising molecule in the laboratory. There's a series of tests that follow in human and then animal tissues, and then eventually live animals that identify how it is biologically promising. The next step is formulating a product, which means that molecule, which is the active ingredient, and then a variety of other inactive ingredients like preservatives, picking a dosage form, picking a route of administration, picking a strength. And then there are several phases of testing in humans. We call those clinical trials, assessing the drug's safety and effectiveness, sorting out exactly what the right dosage is, the right disease or disease state, and the outcome that can be achieved if the drug is administered. And then with the right results in these trials, the Food and Drug Administration, FDA, may approve the drug, which will allow the company to market it. This process can take 10 years and can cost for a new molecule as much as $1 billion, $1.5 billion. For a while, the company has the market to itself, perhaps because of patents, and always because for a period of time, FDA statute doesn't allow it to approve copies that aren't supported by their own research, copies that try to rely on the first company's research. This means for that time period, the company can price its product, its drug advantageously, recover its investment, and make a profit. People complain about the high price during this time, of course, but they know that eventually that company's exclusivity in the marketplace is going to end. All right, the problem is, as I said, there are thousands of prescription drugs on the market without approval. Many of these have been on the market for half a century or longer. Most of the companies think they fall within an exemption, but they're wrong. They don't. Physicians often have absolutely no idea that what they're prescribing isn't approved. Are these drugs safe and effective? Well, when it comes to medicine, those terms are not meaningful, all right, because nothing, for example, is always safe. Water, as you know, is not safe if drunk to excess. Some of them are actually unsafe. A few years ago, FDA took action against a vitamin E injection that killed about 40 babies. But safety is relative, and it always depends on what the drug does. All right. Are they effective? Well, we don't know, and I'll get to why that is. So FDA, and I promise I didn't see Tom's slides, his regulator's dilemma when I wrote this slide. It's just a coincidence, a happy coincidence. FDA faces a dilemma with these drugs. All right, no reasonable company that has been marketing something for 50 years or 100 years is going to invest hundreds of millions of dollars or $1 billion to support a marketing application unless it's forced to do so or really strongly incentivized to do so. FDA can't force these companies to do this unless it threatens enforcement action. Threats of enforcement action are effective only if they're backed up by actual enforcement action from time to time. That is, for these drugs, very, very fact-intensive, very, very expensive. FDA does not have the funds, Congress has not given it the funds to engage in this kind of dispute with respect to each one of these unapproved prescription drugs in the market. The other problem is, an enforcement action is going to take a drug off the market that patients have been relying on for a very long time. So FDA just removes the drugs when there are safety problems. If 40 babies die, okay, now we're going to take the drug off the market. But the problem, one of the problems, is these companies are flouting the rules that everyone else is following, and it's likely that many of the drugs would not pass the test if they did the research that was actually needed for approval. So what FDA does is it encourages firms to do this research. And it does this by promising that if you do the research and get approval, we will take enforcement action against all the other companies marketing exactly the same active ingredient illegally. All right, that provides a reward to the company that invests in the research because it will allow that company's drug to be alone on the market for a period of time. Typically, it's 3 years because federal law will prevent other companies from doing generic copies for about 3 years. And removal of those competing copies plus a prohibition on approving removal of the competing illegal drugs and the temporary prohibition on approving copies gives that company a short period of exclusivity in the market during which it can recover its investment and some profits. All right, that is how the agency incentivizes it. From the perspective of the patients, though, and the payers, what has happened? They've been taking something for a very long time, it has been extremely inexpensive, and then, wow, it's suddenly expensive. That's the perspective, and a lot of people wonder, is the new drug approval worth it? So that's the question. What are the benefits and the costs of applying the new drug authorities? And that's sort of what I tackle in the paper that I'm describing here. And my description of the benefits here is different from what you will see in other scholarship, all right? First of all, holding a treatment to the new drug standard means that 3 things are true, and I have them up on the slide here. Substantial evidence of effectiveness, enough safety testing, and the benefits outweigh the risks for most of the people most of the time. The first one of these is key. It means at least 1, preferably 2, randomized, controlled, yes, I'm reading the first bullet, I don't usually read my slides, double-blinded, prospective interventional trials. All right, what am I talking about? A prospective interventional trial is one in which an investigator administers an experimental treatment to subjects, here you get this, and then takes measurements from them. Randomization and controls mean that the investigators randomly assign people to, you get the drug that we're testing, and you get a comparison. You get a different drug that we're going to compare, and you're randomly assigned. And double blinding means that neither the patients nor the investigators know who's getting which drug, all right? And randomization and double blinding reduce the potential for bias and the potential for confounding variables, all right? And if these trials are sufficiently large to allow meaningful conclusions from the results, what you get is proof of causation, all right? You get conclusive proof that the test drug is effective, it causes the therapeutic benefit you care about. We don't know this about the unapproved drugs that I have been talking about. We don't have this kind of data. All right, the second benefit of the new drug authorities is the gatekeeping mechanism. And the idea here is that federal law ordinarily prohibits distribution of a medicine that isn't approved. And what that does, of course, is it helps to ensure that patients only get drugs that satisfy the standard I was just talking about. That didn't happen here, obviously, but there's more to the gatekeeping mechanism, just so we understand. One of the things it does ordinarily is it ensures that a single entity, here a federal agency that comprises mostly scientists, assesses whether that standard has been met for all drugs for all patients. And these are scientific questions, okay? Whether the effectiveness data amount to substantial evidence, the way I just described it, whether the applicant has conducted all of the safety testing that is reasonably applicable, those are scientific judgment calls, all right? Scientists can disagree on the particulars, for example, whether the endpoint, the thing that you were measuring in the trial is kind of subjective, you know, did you feel better that day? They can disagree about whether the endpoint is a good one, but they can't disagree about what kind of inference you can draw as a statistical matter from the design of a trial. All right. Whether the benefits outweigh the risks for most of the people most of the time, that is partly informed by scientific questions such as what else is on the market, but it is also probably also a judgment call. The low rate of turnover at FDA among the people that make these kinds of decisions helps to ensure that the decisions benefit from a lot of expertise and a lot of institutional memory. That ensures predictability, I would say, as well as consistency with precedent, which are, in my view, hallmarks of a good decision-making process. Some people think that gatekeeping addresses information asymmetry. That is one of the justifications. It's frequently offered for it here, but it's not correct, because at the outset, when you have a molecule that you have just identified as biologically useful, there isn't actually that much information asymmetry. All right, the primary contribution of the gatekeeping mechanism, in my view, is that it ensures, well, that it requires the generation of information in the first instance, because a company has to do all of that testing that I just described in order, ordinarily, to market its product. I will say right now that it should be clear that the unapproved prescription drugs I have just been talking about provide a pretty powerful response to arguments that competitive market pressures and concerns about product liability are going to ensure that companies do the full suite of safety and effectiveness testing that we've all come to know and love, because, in fact, it's manifestly not the case. These companies have not done it. The other thing that the gatekeeping mechanism does that people don't usually identify is that it ensures that information about the drug is actually disclosed to doctors and through doctors to patients, and it also provides a mechanism for regulating what is said exactly. And this is because FDA controls the labeling that is given to physicians. It's a 30,000-word document that sort of synthesizes all of that data. All right, and that is governed by detailed regulations and guidance. And so what happens is gatekeeping is improving the flow of meaningful information about medicines to patients by ensuring that that disclosure satisfies a particular standard with respect to the content, the word choice, the level of detail, and so forth. And it promises some consistency in terms of judgment call. All right, the last benefit of the New Drug Authority, which nobody has written about, which is part of the focus of my article, is that it provides a leash on the drug company, all right? It is, new drug approval is not like a barn door and all the horses run out. It is basically a mechanism for control of the drug and the company for the life of the drug. So, for example, any change to that labeling for doctors is regulated, has to be approved by FDA. There's a continuing flow of clinical information to the agency. Anytime there's any kind of adverse event, it goes to FDA. It can order more clinical trials. It can order labeling changes. It can order distribution restrictions in response to that information. It has intense control over the manufacturing of that drug because of the application, the approval as well. Changes to the manufacturing process. FDA doesn't have any of this with respect to the unapproved prescription drugs that I am concerned about here. All right, so everything is there in tiny font, you've already heard. All right, the question is, what does all of this cost? All right, objections to this paradigm usually focus on the barrier to entry, not on the basic notion that medicine should be, the benefits should outweigh the risks, okay? Many of the people who are concerned about gatekeeping are motivated by, and this goes back to Tom's initial comments, the risk of type 2 errors here, which are rejection of drugs that are actually beneficial, okay? Many believe that the agency routinely commits these errors because it is risk averse. It gets hauled in front of Congress when it approves something that harms people. It doesn't get hauled in front of Congress for not approving things typically. All right, and of course, every time it turns out after 10 years that the drug was safe and effective, that's 10 years worth of patients that didn't get treated. All right, not true here with the unapproved prescription drugs, of course. The question for policymakers has always been, how do we minimize this risk without increasing the risk of the type 1 errors, meaning the approval of the harmful drugs? You can't get rid of the type 2 errors completely by removing the gatekeeping mechanism because it creates a new problem. What does it do? Well, it might give patients and doctors immediate access to anything they want, but because the gatekeeping mechanism also ensures the creation of valuable information, and nothing else apparently does, if you get rid of the gatekeeping mechanism, they can have the drug, but they don't know anything about it. There's also a deeper cost to new drug approval, which is how expensive it is, all right? Developing a new drug is really expensive work, as I said, and the gatekeeping mechanism in and of itself does not ensure that companies will do the work, right? They might just invest in a different kind of, in a widget that doesn't have a barrier to entry. Here, it doesn't ensure, as obviously, that companies will bring their unapproved prescription drugs into the fold. Whether a company is going to spend all this money instead of investing in something that doesn't have a barrier to entry is going to depend on the competitive landscape that it anticipates, in particular, whether it expects to have the opportunity to recover its investment and make a little money at the end. And that means exclusivity in the marketplace. For the unapproved prescription drugs, if we want to bring them into the fold, that means taking enforcement action against the other companies. All right. The problem, of course, is, well, let me as Tom has said, what are the alternatives, right? The other thing you could do is just say, well, we value new drug approval and all that data generation, but maybe the government shouldn't use this leverage with respect to these drugs. Let's just have those companies disclose how much evidence they have. If you don't also know what the gold standard actually is, you don't have any way of comparing. You don't know what you're looking at. So you'd have to disclose all of the data, so the gold standard data for the approved drugs as well. Well, one company famously reported that its new drug application, sheets of paper piled on top of each other, reached the top of the Empire State Building. You don't have time to read that. Your doctor doesn't have time to read that. Scientific illiteracy is also a significant problem. It's unfortunate, but physicians often don't appreciate the distinction between observational data, anecdotal data, and the gold standard that I was talking about. And anyone you ask to do this, even if you assigned it to a third party, is going to have the problem they don't have the hundreds of years of experience that FDA has through all the people and decades of reviewing of applications. So, in my view at least, the disclosure alternative is going to lead to less informed decisions. And there's one other issue with the disclosure-only solution. If somebody studies the drug and gets it approved, and these companies are just doing disclosure, then you've got both products on the market. And there's not a good medical policy for having two treatments with the same active ingredient for the same thing, supported by wildly different amounts of scientific data. Well, you might think, okay, the differential in price means that everybody gets treated, some people with the crappy drug, pardon my language, and some people with the one that's actually tested. But what we know from some precedents is that, in fact, the possibility that that's going to happen keeps these people from doing the research in the first instance. Because if the agency leaves these unapproved products on the market, these companies go bankrupt. So the other possibility is if you opt for disclosure, no one's going to actually do the research to determine whether the drug actually treats the disease in question. So this is sort of where I am. The key costs of the new drug authorities are typically the risk of type 2 errors, more or less costly depending on the situation, obviously, and the cost of encouraging companies to actually do the research. For these drugs, you don't have a risk of the type 2 errors because they're already on the market, so we're not going to be blocking beneficial drugs from being on the market, from getting to patients. But we do have the high price of exclusivity. The thing to remember, I think, is that patients perceive themselves to be paying suddenly a lot more for the medicine, but they aren't. They're paying for something different, all right? What they got originally was an active ingredient that wasn't approved. What they get now is a particular product, the formulation, the route of administration, dosage form, and strength that has been run through the gold standard testing, proven definitively to cause the benefit in question. They are paying for the labeling that has been written, synthesized, and regulated by FDA. They are paying for FDA's review of the manufacturing process. They are paying for FDA's supervision of the company's adverse event reporting afterwards. They are paying for FDA's control of the labeling throughout the life of the drug. So it is a different product. So I think the problem here is a problem of public perception. I think that many of the benefits of the new drug authorities are invisible, and where they're visible, they're poorly understood. And I think the public doesn't see or appreciate the elimination of type 1 errors, meaning the approval of drugs that cause harm, and it mostly doesn't understand or appreciate the quality or quantity of evidence supporting approved drugs or the efficiency gains from FDA synthesizing the information. And the benefits of the new drug leash, I think, are also largely invisible. The costs of the new drug authorities are very visible and very painful, and that is why we find ourselves in the situation we find ourselves in, where I think the actual appropriate solution for the regulator is to remove the competing drugs from the market in order to incentivize people to actually do this research. But the pain is real and is an impediment, I think, for the agency. All right. Thanks.
That was quite a lot of meat from all our panelists, and it's raised a lot of questions, certainly for me. But before we take questions from the group, do any of you want to respond to anything anybody else said? I mean, obviously you've talked about very different things, but let me give you a chance to ask questions before we open it up.
Well, just I have a microphone now. I just note there were at least a few interesting themes running through all of our discussions, comparing regulatory alternatives and understanding what the costs of a regulation are versus the benefits. Interesting discussion about the role of gatekeepers in various industries as well, the role of transparency in providing information to consumers versus their ability to use it, and the costs of that information on both the sources of and the users of the information. So an interesting set of commonalities. And that was a non-exhaustive list.
I don't know if I could comment briefly on both presentations. To me, the really exciting revelation from the FDA stuff was I never realized there was this almost parallel marketplace out there that operates under a different set of rules. And to me, the really exciting thing was, gosh, there might actually be a way to use the experience in that marketplace as data to try to figure out what the optimal way to regulate might actually be, which is a different paper from the one you're writing, but I mean, this could be the gift that keeps on giving in terms of research.
Yeah, oh, absolutely, absolutely.
And Gus, my main comment, I really appreciate that you pointed out that people tend to get attracted into specializing in technological issues because they're good with technology. Because I've noticed a tendency in following the FCC over the years that, on issues like broadband, and they're trying to figure out what counts as broadband for the purpose of universal service subsidies, which are subsidies to low-income people or subsidies to people in rural areas, which, as we know, people there are inherently more deserving, or inherently deserving of subsidized things. And by the way, I live in a rural area. That people get attracted by the technology, and there is a tendency, because I'm enthusiastic about the technology, to say, oh, well, this is the level of service that everyone ought to have, rather than asking, well, you know, what do consumers actually want and they're willing to pay for, and what trade-offs are they willing to make? And personally, I've found that often the FCC experts are willing to presume that everyone should have a certain minimal level of broadband service that's well above what I feel like I need and am willing to pay for.
In psychology, we refer, well, I'm not a psychologist. In psychology, they refer to that as the fundamental attribution error, attributing your own circumstances to those of others. So I think this is what I need, everyone else needs this. This actually, this prompts for me a question. I don't know on the health side. My intuition is that folks don't go into health law thinking, the system is working reasonably well, how can we fine tune it? My intuition is that we probably have more folks, especially students, coming to law school and getting excited about health law from the perspective of there are problems in the health system, I've got ideas how to fix it, so I'm going to go into this area to implement my regulatory solutions.
Yeah, I think that's true, and I think they usually have the regulatory solutions in mind before they've actually done any research.
Yeah. So the law schools need to beat this out of we need to beat this out of you. And Tom's book is all about how do we build beating this stuff out of the students into the curriculum. So.
Let's take questions from the audience here.
You know, as part of the rulemaking process, there's a fiscal analysis that's done. I'm just curious, from your point of view, when you see that fiscal analysis being done by the governmental agency promulgating the rule, have you found that it has any realistic, you know, whatever they're putting out there, has anybody kind of gone back forensically and looked at it and said, oh, that was way off, or that was spot on?
It's a fascinating question. So I'm somewhat skeptical of the analyses that I've seen. They're generally very hand grenadey. But one of the things in antitrust law that we talk about a whole lot and never do is the need for retrospective analyses. And every now and then we actually, over the last generation, have started to do these. I don't know if OIRA does retrospective analyses of the cost studies that they review. If they don't, they should. I expect that the current director of OIRA will not be in her job much longer. So whomever's next, we should whisper this into their ear.
Let me add something. If you think about regulation more broadly as not just regulatory, but the government choosing to regulate, having worked on a lot of legislation and scoring process, that, in my experience, in my space, is almost always very wrong. The times when I have seen somebody go back and actually try to calculate the cost, the score's been wrong.
Yeah, retrospective review, I mean, not just of the fiscal effects, but of sort of all effects of regulation, isn't done that much, at least in regard to federal regulations. To those of you who really want to get in the weeds, just keep in mind the Office of Information and Regulatory Affairs in OMB produces an annual report on the benefits and costs of federal regulations. But if you drill into it carefully, what you find is that it is a compilation of the agency's predictions of the benefits and costs of regulations that they're adopting. It's not an actual retrospective assessment. And by the way, OMB is very straightforward and honest about, you know, the limitations of that approach. It's not like they're trying to hide something, but typically people don't read the whole thing and don't realize all the caveats attached. But yeah, I mean, it's well known among regulatory scholars and others that there isn't a whole lot of retrospective analysis, and there's a big need for it to find out what's actually working and what's not working.
It could be something that, say, the George Washington Center for Regulatory Studies could take up.
Yeah, in some cases, though, to do a really good retrospective analysis, you really do need subject matter experts, rather than not just kind of, you know, generals who know regulation in general. So And that's probably why it's not done as much.
There was some very good work done. The 1962 changes to the Food and Drug Act added a requirement that drugs be shown effective and substantially increased the pre-market timeline for drugs. And there was a lot of very good economic work done in the 1970s, late 1970s, early 1980s, assessing the cost of regulation. And the big one was a paper by a book actually by Sam Peltzman at Chicago, who concluded that in fact the benefits of the 1962 amendments were not worth the cost.
On the issue of retrospective analysis, I've asked Jerry and anyone else really, whether and to what extent they think that the recent executive order, the president's order, the 2-for-1 order, combined with the regulatory cost cap for the agency from year to year, might in effect provide a form of retrospective analysis going forward.
Yeah, I think the administration took a lot of grief for that executive order because a lot of critics said, oh, well, now they're just making decisions about regulation based on cost, not on comparison of benefits and costs, although that order also says, oh, by the way, the previous executive orders are in effect and we expect decisions to be made based on benefits and costs. But yeah, I think your point's exactly right, that if an agency has to find 2 regulations to eliminate for every new one, and or has to find regulatory cost savings equivalent to the cost of a new regulation, then that's a pretty obvious motivation to go back and look at old regulations. And that's what a lot of federal agencies are doing. Now what federal agencies are grappling with now is kind of the same problem of, you may have heard of the store owner who says, I lose money on half the stuff I sell, I just wish I knew which half. Similarly, I mean, the agencies have a very real challenge of trying to figure out, all right, we have all these old regulations, which ones should we look at first in order to try to figure out whether they're working, whether they should be changed, whether they need to be eliminated or whatever. And they're for advocates of retrospective review, it's kind of now being the dog that caught the car. There's now an incentive for agencies to do this, and we have to help them figure out how.
Yeah, there's another interesting aspect. So the executive order, I personally think that the 2-for-1 aspect of it is kind of silly because it's not comparing cost apples to cost oranges or benefit oranges, but it embodies a really fascinating idea, which is kind of impose pay-go on agencies for their regulatory costs. And that in and of itself is a really interesting idea. We don't think of agencies as having a regulatory cost budget. We kind of tell them, go out and regulate, and if your regulations impose $10 of costs or $1 billion of costs, so long as you're complying with will of Congress's edicts, you pat yourself on the back. The idea that there is a regulatory cost budget that you need to stay within is a fascinating and different way of thinking that I think the executive order isn't expressly designed to do, and there are problems with just saying whatever your historical costs are, the costs that you've imposed are, that's your new budget. But I mean, I am a big fan of saying, hey, you've got trade-offs. You need to prioritize your trade-offs, and scarcity drives efficiency. And if we don't have scarcity on regulatory decision-making through agencies or Congress, we don't have efficient thinking.
Anybody else?
Mine's for Professor Elliott, and I think it's a rare opportunity for us to be able to have someone like you who has so much experience in so many different levels of a federal agency. And so my question's a little big. And by that, what I mean is, with all your experience, when you look at the FCC, what should it be doing? What shouldn't it be doing? If you were king, what would its job be?
I'm just pausing because that is an incredibly big, high-level question. Yeah, let me temper my answer by thinking about, you know, what might kind of be realistically achievable rather than sort of the ideal. I think one thing that could improve things tremendously, and that may be realistically achievable somewhere in my lifetime, would be if the standard that the FCC had to use to make decisions were changed from the public interest, which, as Senator Clarence Dill, who put those words in the Communications Act, said means it covers just about everything, which means whatever 3 FCC commissioners at any time say is the public interest pretty much counts as the public interest. If the standard were changed from the public interest to some type of a consumer welfare standard more in line with what's now used in the antitrust laws, because you would have much firmer grounding in economics. You would have much firmer grounding in actual evidence and empirical research. Because right now, under the public interest standard, it's almost a license for an individual commissioner or a majority to say, well, because I can say this word that articulates some value that isn't normally considered part of economic analysis, like privacy or fairness, just because I say that word, that lets me win the argument and get my way, providing no evidence whatsoever that the approach I want to take really will achieve or improve this value in some way that we can identify empirically. And a lot of decisions get made in that way. Yeah, it was crazy. When I was there, I would ask the deputy chief economist, who's a career employee, is an expert in media and media regulation. And they would talk about things like localness. And I'd say, well, how do they know whether a decision is improving localness or reducing localness in media? And he's like, well, okay, it's not, there isn't like some measurement that tells you whether localness has gone up or down. There are some little scraps of information here or there that you kind of look at, which are often anecdotes. So that's one thing I would think would make a lot of sense, that would kind of cross-cutting improve a lot of FCC decision-making by providing kind of more concrete guidance to how they're supposed to make decisions.
Well, we got to end here, I think, so we can get back by 1 o'clock for Commissioner Peirce's talk. Lunch is provided out in the, I'm assuming it's set up out there. So take a break for an hour and 15 minutes or so, and we'll see you back at 1. Thanks.